All right, good morning or good afternoon. My name is Nick Scala. Thanks for joining us today for Con Carey's third webinar of the 2025 MSHA webinar series. Today we'll be discussing MSHA whistleblower updates and understanding the 105C retaliation and whistleblower provision of the Mine Act, along with the investigations that go through that. As you guys know and have joined us before, my name is Nick Scala. I am the chair of the um, Mine Safety Practice Group here at Con Carey. I'm joined today by my colleague Scott Hecker, who I will let introduce himself here in just a moment. Just kind of lay the land as we get things started in terms of our agenda. I mentioned what we're going to talk about at a high level, but broken down a bit more. We'll touch base on some of the updates as we continue to have changes and moving pieces around the administration change and with the leadership of the agency and how that might impact the 105C process. So we'll touch on that to start things off, and then go through evaluating the complaint process and responding to those complaints under the Mine Act, Section 105C, and then end up with some tips and best practices to help you guys succeed there. As I mentioned, I am the head of our Mine Safety and Health Practice Group here. We help employers all over the country dealing with MSHA, litigating MSHA and OSHA matters, helping with compliance assistance and rulemaking. And part of that is managing investigations and helping facilitate responses to things like whistleblower discrimination claims. I'll turn it over to Scott to introduce himself, and then we'll get started.
Thanks, Nick. As Nick mentioned, I'm Scott Hecker. I'm in our DC office, senior counsel, came to the firm after some time in other law firms, as well as time at the Department of Labor, 10 plus years there, almost a dozen years. Part of that involved trial and enforcement work around MSHA, out in the Arlington Regional Solicitor's Office, doing a lot of coal mine work, including 105C cases. And have been on both sides of these matters, and of many MSHA and OSHA workplace safety matters. So happy to be involved in the discussion here today. We're gonna again jump in, as Nick said, with a quick kind of overview of where we are with the Trump 2.0 administration. We're all familiar with the sort of budget cuts and streamlining that the Trump administration's undertaken, primarily through Elon Musk's Doge organization. And, we can't really guarantee exactly what the priorities and policies of the administration are going to look like for MSHA this time around, but we can kind of look to the past to get an idea of where we might go. And the expectation would be, a little bit of a reduction in force when it comes to the enforcement personnel for MSHA. One sort of wild card on that issue is the Secretary of Labor, Lori Chavez DeRemer. She brings a more pro-union approach than a lot of Republicans. She at one point supported the PRO Act, which is very labor friendly. And so she could have more of a worker perspective than maybe we've seen at the top of the department in the past from the Republican side. Wayne Palmer, who's been nominated as the Assistant Secretary for MSHA, was the acting Assistant Secretary under the first Trump administration, and then was the Principal Deputy. So he's very attuned to the policies and procedures that were implemented the first time around, and so has a familiarity with those, can build on those, but also with his background in the MSHA administration. Should know sort of how to pull the right levers for whatever policies are going to be implemented this time around. You see there, Doge has come calling to MSHA. There are offices targeted for closure, 34 of them in 19 states, which certainly will impact enforcement. If everyone needs to be in the office and there are fewer offices, it could be difficult to get folks out in the field, and really could limit the ability of MSHA to fulfill its statutory obligations to get out in mines either quarterly or semi-annually, depending on the type of mine. But yeah, when you have reduced personnel, reduced footprint, it really could crush MSHA enforcement to some degree. We don't want to overstate it, of course. And again, we're not sort of guaranteeing anything, but and we do understand, and Nick may speak to this too, that there's some pushback from MSHA just based on the fact that they do have obligations under the MSHA Act to inspect at a certain cadence. There's also obviously a deregulatory effort underway under the Trump administration. There was in the first administration. It's even probably further ramped up in 2.0. But one thing to note about the MSHA Act is there is a section 101A9 that basically requires no regulatory changes that will reduce the protection afforded to minors. So it may be difficult to pull back certain regulations unless the Trump administration can demonstrate, equality in protection between where they stand now and what the administration might propose. So that is one limitation on the deregulatory efforts that we're seeing, across the government right now, and including, the efforts to potentially not go through notice and comment rulemaking where, there's good cause to avoid that. Trump has pushed the idea that recent Supreme Court decisions maybe already make certain regulations illegal and they should effectively be immediately withdrawn. But again, there may be some tension there with the MSHA Act itself. Nick, I know you had some thoughts as well, so kick it back to you.
Yeah, yeah, thank you. No, I think you hit the high notes there fairly well. I mean, still some unknown, but we know the players that are moving through the pipeline. So hopefully we'll get the Assistant Secretary confirmed and Ms. Wayne Palmer in there, sooner than later. Historically, that has, been late late third quarter, early fourth quarter, maybe of the first year in office. So that'd be this year. But sometimes it even extends into the second year. The administration really came in this time with a lot more laid out plans in terms of staffing and where people would be nominated and placed. So hopefully it will move through quickly because the agency really does, sputter in general if it doesn't have that confirmed leadership in place. And that's not unique to MSHA, but really any of these agencies or administrations that are being run as part of the executive branch, they really need that, or else you just kind of see more of a continuation of what has been the case, maybe moving forward. And we saw that a lot in Trump's first administration when OSHA went without a confirmed assistant secretary for the entirety of that administration. So I think that having Wayne get through that confirmation process would be very good for everyone. And the fact that he has some experience at the agency before, I think that's a very good thing. I know that there has already been some pushback with MSHA and Doge cuts, particularly with the probationary employees. They were seeking to have those persons retained rather than laid off. Expect a similar approach with the office closures. And I think Scott, laid it out pretty well that it's really logistics. And unlike some other federal regulatory agencies, MSHA has mandatory inspection requirements, right? They have to report back to Congress on whether or not they're completing their twos and fours, as it said. So they will leverage any resources they need to in order to get that done. And if they're not fulfilling their mission, which Congress mandated and gave to them. So there's not a great deal of wiggle room right now under the Mine Act, unless it's changed for them to, walk away. And from the people at the agency that I have talked with of late, the priority is going to be on twos and fours right now, and that's what it's expected to be for this time moving forward. The Section 101A9 is an important one. We talked about it on our last webinar as well. That was in respect to the silica rule because we think that's probably a likely mechanism of challenge by the unions if the Trump administration is going to modify or attempt to modify the silica rule at this point. And we saw that happen in the first Trump administration when they modified the reg on metal, non-metal workplace exams after it had become final from the Obama administration. So that is certainly something in this deregulatory scheme that is going to be challenged. The unions have a roadmap, particularly for the Mine Act, to litigate this, and we're successful in doing it in the 2019, 2018, 2019 case on the workplace exam rule. So, do we think that the agency is going to, be stripped of all regulation? I think that's probably unlikely, but it's certainly the deregulatory agenda is the focus, but there is a mechanism to challenge that, and I would expect the unions to become active there. They're already attempting to become more active in the silica rulemaking, or I should say the silica litigation, making the argument that MSHA is not advancing the interest of the miners at this point. So I think it's potential that we could see a very active kind of union presence with any kind of deregulatory agenda. Um, kind of looking back at what we've seen and how we're not sure how it's going to move forward. As Scott mentioned, we have well, for the Republicans, a very pro-union, a Secretary of Labor and Secretary Chavez DeRemer. Um, so, that doesn't mean necessarily as pro-labor as we've seen the last 4 years, almost certainly not. But still, something to keep an eye on and note. MSHA on the 105C front has taken a very active role in trying to get education out there on 105C rights to minors, and I'll educate them on the mechanism for making these complaints and how they move forward. It's been a talking point. It's been part of, emphasis programs in terms of MSHA Silica emphasis program. Part of it was educating minors on their rights and how to make a complaint. And that's often how we get into a whistleblower complaint is it's from a complaint to MSHA on safety side. But we'll just go ahead and keep moving along there because I think that goes well into our next slide and topic. So let's go ahead and just jump into MSHA complaints under Section 105C. What is the whistleblower protection? What is the Section 105C and what does it say? So this is a provision of the Mine Act that says that no person shall discharge or in any manner discriminate against or cause to be discharged or cause discrimination against or otherwise interfere with the exercise of the statutory rights of a minor. So that means that, what are those rights? It's protecting minors from exercising these rights, meaning that they have the right to refuse work if they have a good faith belief that a condition is unsafe or unhealthy. They can make complaints for safety or unsafe conditions to MSHA or to their own employer. This can be made, by a minor or a minor's rep, or even it can be extended to an applicant minor. They have the right to participate in any proceeding under the Mine Act, whether that is a citation contest or another discrimination complaint. In the Part 90 section, and with respect to black lung, it's to have medical evaluations leading to a job transfer because of toxic substances or reduced lung function. Or these are generally where we see it. Typically, these protected activities that Scott will talk about later on boil down to complaints made to MSHA or complaints made to a manager or someone else about an unsafe condition at the facility. And, if that has been done, if someone is going to take that, they have some protections under Section 105C. And those protections are against being discriminated against, which can be a form of termination or demotion or suspension. Those are kind of the typical areas that we've seen discrimination for exercising these rights. So maybe they, you know, in the very, very straight line version of this, call MSHA and file a complaint about unsafe conditions. And then the employer finds out and terminates them. This would be a pretty classic kind of retaliation, discrimination against someone for exercising that right. It's very, very, very rarely, if ever, as straightforward in my experience. But that is what the discrimination protects against. And then also MSHA has a interesting provision about interference, meaning that mine operators cannot do anything that would interfere with the exercise of miners' rights in the future. Um, so, I think again, kind of the straight line example would be, telling everyone that if you call MSHA and file a complaint, you will be fired. That would be seen as interfering with a minor's ability to exercise their right, and therefore, could be investigated under Section 105C, and MSHA could have a finding against an employer for Section 105C. And, when we go through this process, there are complaints made, investigations are conducted. MSHA makes a determination about whether or not they think the complaint has merit or not. And if they believe it has merit, they will take it up and file a complaint again before the Federal Mine Safety and Health Review Commission and its administrative law judges, um, seeking typically a civil penalty against the operator. So a fine, they will fine the operator. They're typically pretty heavy fines in the thousands and tens of thousands of dollars. Um, if they find that there is merit to this. And also they typically are going to seek some kind of damages on behalf of the miner. Now, if someone's discriminated against, and they move forward, it could be for lost wages, or it could be for reinstatement to the job, um, which Scott will talk about as we get further into this presentation. But MSHA will be seeking something. In the interference claim, typically there hasn't been necessarily damages sought, but they will still seek a penalty and they will still evaluate whether or not damages are appropriate and available, and if so, seek them. The whole process here is managed by the division of MSHA called Technical Compliance and Investigations, or TCID. They have a great deal of oversight over these and they move quickly. And they have a lot of attention on them when they do get picked up. So you will have a special investigator who takes the case. They'll have a supervisor involved that is reviewing the work as they go. Then the district and or regional administrators and district managers get involved and have a role to play in reviewing it and determining how it moves forward. And then it will go through the national office and TCID, and even get the solicitor's office involved in some cases before the case um, actually has a complaint filed, which Scott can probably talk to from his experience working on these cases on the other side earlier in his career. So as we talked about, it extends to people who are acting in these areas that are protected under the Mine Act. So engaging in safety and health related activities. I could be identifying hazards or asking for an inspection or refusing to engage in an unsafe act, as I mentioned. These are given priority over all other SI cases. So, if you've ever been in a special investigation under 110, sometimes they can get drawn out and they take a long time to move forward. I know I've met it multiple times. I've been handling those with clients, and all of a sudden the inspector or investigators just said, I got to take a 105C, and it gets priority over that. So these are an area where we typically get a lot of attention, and it moves quickly. And it's interesting because, this is available not just to miners, but also to representative of miners. So if you have a miners rep at the facility or in your operations, that person who's been nominated and elected by others to kind of be that miners rep in a union facility, this person would also be able to file a discrimination complaint or an interference complaint if they feel that the operator has taken actions which have been either retribution for engaging in safety related activities or protected activities, or taken steps to interfere with their ability to act as a miner's rep, which is actually one of the interference cases that Scott will probably touch on later, that were from about, I would say probably a decade ago, maybe a little more, but where a group of miners reps filed complaints saying that they were not able to act as a minors rep because of actions of the employer, and that was interfering with their ability to do that. An interesting one is also that applicants for employment can file a discrimination complaint. This is much less likely and not as common, but it does happen. I've seen it before where, especially where maybe a manager at your operation previously worked at another location and maybe at that location worked with that particular applicant. Um, and the applicant may feel that activities that they um, took at that former mine or the prior mine where they were working with that manager, you know, resulted in them not getting the job. Now, obviously, that's a difficult argument to make sometimes, and you're dealing with much more attenuated timelines in terms of when these protected activities occurred. But nonetheless, it is an option out there. That is one of the classes that's offered protection there. But with that, I think I'll turn it over to Scott and let him dive into some of the elements of these claims.
Yeah, thanks, Nick. So obviously this is, the whistleblower space is a bit more employment law related than maybe some of what we deal with in the regulatory MSHA framework more often. And when you're looking at the elements of retaliation or whistleblower claims, there's sort of four keys here. There's the protected activity that Nick talked about. What the minor needs to demonstrate what the protected activity was that he or she or they engaged in. That they claim there was an adverse action in response to. So that would be showing that the employer then took some sort of action in response to the protected activity that was adverse to the employment, to the minor's employment. And from that, there does need to be knowledge by the decision maker who made the decision to take the adverse action that the protected activity happened. So you can't just sort of suggest that something happened and without anyone's knowledge, an adverse action occurred. There needs to be that connection, and beyond that, there needs to be a causal connection that the employer would not have carried out the adverse action but for the protected activity, meaning that's basically the cause of the resulting adverse action is the protected activity that the employee engaged in or allegedly engaged in. Again, these are things the complainant, the minor representative, the applicant for employment would need to prove to make their case here. These kinds of discrimination complaints, result from a number of different kinds of protected activity, including obviously making a complaint. That's, sort of the likeliest either to MSHA or to your employer, to the operator. Participating in an inspection, you do not want to sort of get in the way of your employees participating in an MSHA inspection. They have the right to do that. If there's an enforcement action and they cooperate as a witness, something along those lines, that's another thing that is protected. Refusing to work in unsafe conditions or unhealthful conditions, again, sort of exposing yourself to a hazard. If they report that, cannot take, that's a protected activity under the Act. And getting the appropriate training, required training. If that hasn't been provided, a minor may be able to step back, not perform that act. It sort of goes a little bit in line with refusing to do unsafe work. If you don't have the proper training, then you might not be executing the work properly. It could be unsafe. And so those are a number of the types of protected activity that a complainant might raise or allege in making a 105C claim. And from that, a lot of these come from result from Section 103G, which concerns whether there's a reasonable belief that there's an imminent danger or a violation of a safety or health standard, or a general, violation of the Mine Act more generally, not just the regs, but perhaps a statutory provision. Is that communicated to MSHA by someone who is a minor or a representative, or again, we've mentioned applicants, though that's perhaps less likely in this context. And then was there a name associated with it or some sort of contact information from the person making the complaint? And this is sort of fertile ground for complaints, for 105C complaints, is making this kind of submission under 105, oh, excuse me, 103G of the Act. When MSHA arrives to investigate a complaint like this, they should provide a redacted copy or summary of the allegations so that the operator is aware of what's going on. And then Nick mentioned the teams that investigate these. They'll be investigated. The complaint will be investigated for a positive or negative finding that's going to be reviewed by supervisory personnel in the district. And so, these are the kinds of things that should not, again, be retaliated against or discouraged. We do note there that it's possible for a non-minor or an anonymous complaint to be submitted. That would be something that's either communicated by someone who doesn't fall into those categories of a minor or a minor's representative that we discussed previously, those protected categories of worker who can bring these kinds of 105C complaints. Or, it's just, we mentioned you should provide contact information when submitting a 105C. There should be some, identifying factor when submitting that kind of complaint under 103G to OSHA, excuse me, to MSHA. But if the person determines to submit anonymously, that is allowable as well. There's some confusion in the MSHA guidance that Nick and I were discussing recently that about whether a complaint summary or copy of the redacted complaint needs to be provided when there's an anonymous or non-minor complaint, and MSHA may sometimes use that confusion to withhold a copy of that non-minor or anonymous complaint. We suggest that you still push for it in writing, that you still try and get a handle on what is being investigated so that you are able to address it fully, appropriately, thoroughly, comprehensively with MSHA as they conduct their investigation. But again, there is some confusion. There's some tension in the guidance that doesn't make clear whether a non-minor or anonymous complaint, whether MSHA then needs to provide a copy of that to the operator upon arriving for the inspection. And looking at our next slide here, just sort of the next steps that occur once a complaint comes into MSHA. There are a number of different types of potential hazard or violation that could be identified. If an imminent danger is alleged, the authorized representative will notify the operator. Will let the operator know that they got a complaint about an imminent danger and direct the operator to investigate that immediately. Obviously, it's imminent and they want to deal with it promptly. And there's sort of no reason or justification for delay there. There will then be an on-site by MSHA as soon as possible to identify, whether there is an imminent danger and how it should be addressed. So that's sort of the top of the line with speed that Nick referred to earlier. That's probably the one that would move the quickest. For a serious hazard or violation, there'll be an investigation by an authorized representative, by an inspector, as soon as possible without prior notification. So again, in the context of the imminent danger, the operator is going to learn about it so they can address it as promptly as possible. When it comes to a serious hazard or a serious violation allegation, there won't be warning, but MSHA will be on site as soon as it can be. When it comes to technical or non-serious, the AR may conduct an investigation as soon as possible. Again, there won't be notification to the operator, but there's an alternative possibility where an investigation of that technical or non-serious violation could be rolled in to the next mine inspection. Excuse me, the next mine inspection of those 2s and 4s that Nick mentioned previously. So there are options there. And then when there's not a violation, or it's outside of MSHA's authority to invest the allegation, then you're unlikely to have action. But certainly, the generally you're looking at some sort of activity from MSHA if they receive a complaint and it appears to be something that's within MSHA's jurisdiction. Looking at the next slide here, you can see we talked about the need for an adverse action as part of that sort of four-pronged analysis of the 105C complaint. And this is a listing of, adverse actions that have been found, or excuse me, actions that have been found to be adverse. And I believe, Nick mentioned a number of these previously, but, it's not just firing someone, right? You could see something like a change in duties, or poor evaluation. Those could result or could be grounds to claim an adverse action. So you do need to be careful not thinking, oh, well, we didn't fire the guy, so we're in the clear. That's not the case. You can see also some more amorphous ideas that MSHA has identified on the right side. The reducing hours, making a threat, hostile work environment, such things that are maybe more subjective, than certainly than termination. And so it's something, to be aware of if there's a reaction to what looks like protected activity. You need to be very careful and really evaluate the potential for labeling it as adverse, even if in the first instance you think, oh, well, again, we didn't fire this guy. That's not going to be the only potential avenue to claim an adverse action as a result of protected activity under 105C. We also mentioned the causal nexus and operator knowledge. So these, tend to go hand in hand a bit. There needs to be a connection between what happened, the alleged protected activity that the complainant claims, and what the alleged discriminatory or adverse action, that list of things we just looked at on the prior slide, what is the connection between the two? And part of that, obviously is it can't just be that no one knew the protected activity happened, and sort of consequentially, or coincidentally, I should say, the adverse action occurred. There needs to be some knowledge by the decision maker, or someone who influenced the decision, that they suspected or knew about the protected activity. So there needs to be a knowledge component on the operator's part. And the complainant needs to demonstrate that again as part of their case, those four prongs we talked about previously. You really need to consider it. The complainant will need to bring that, and that is one way to say, hey, look, if you have it, and we'll talk a little bit about documentation later, but if you have it documented that no one was aware of the protected activity, and or the minor was sort of underperforming, there's justification that shows it was not about the protected activity. Those are the kinds of defenses that you can mount in these circumstances. And so on the knowledge piece, just to dig a little bit deeper into it, it does have to be someone who, was involved in, aware of, participated in the decision, whatever the adverse decision was. If the another thing could be if the protected activity took place after a decision was already made. Again, that comes back to documentation. Do you have the ability to show the steps and how they occurred and the timing of those decisions? There could be suspected knowledge. That's not going to be sort of explicit. It may be that, there's a person who made, or a complaint is made about a particular piece of equipment, and there's only, one person that uses that equipment or typically uses that equipment. And then, the operator could infer that that employee was the one who made the complaint. Again, that could be suspected protected activity, could suspect the employer engaged in making a complaint. That could get you across this knowledge threshold, and that could find you liable under 105C. So again, the response, needs to be, you need to manage and not retaliate for these kinds of protected activities if there is knowledge or even suspected knowledge that could be inferred based on the circumstances. But again, knowledge is a key piece here. But, as we note at the bottom of the slide, there could be a potential where there's multiple pieces of a complaint. And so knowledge could be spotty, or there could be knowledge of one thing as opposed to the other. Again, I don't want to I don't want to jump ahead too far, but documenting sort of these kinds of complaints, the activities, justifications for adverse actions, terminations, other, again, reduction in hours, switching shifts, changing duties. When you make those kinds of decisions, it's important to explain why, so that you can defend against an allegation that it was because of a protected activity that the minor or other covered person engaged in. And then again, causation, as we said, there's a sort of the causal connection, the proximity here. Proximity is sort of one way to demonstrate that connection, and that by that we mean that the activity is close in time. The protected activity is close in time to the adverse action. That can be something that serves as evidence that, hey, look, this happened so close, one after the other, that it must have been because of the protected activity that this adverse action was taken. You'll see there, it needs to be very close. Supreme Court has said 3 to 4 months is insufficient. That's long enough to sort of break that chain of causation. But you do want to be careful. Again, you want to pay attention to when you're making a decision. Particularly if it's not well papered. If someone has alleged and made a complaint, and then the next day or even within a week or a month, they're terminated. There could be, an ALJ, the FEMTRIC could consider that, and MSHA itself in the first instance, when it's conducting investigation, could consider that so close in time that it would be evidence of a causal connection based on that proximity. Now we're going to get into a couple of the sort of nuanced issues that arise in 105C, and I believe Nick referred to both of these. But interference, again, you're sort of getting in the way of an operator exercising of a minor exercising their rights. It doesn't necessarily mean that there was a clear, adverse action right at that time. In fact, some decisions suggest that interference itself could be an adverse action. Here, there doesn't necessarily need to be protected activity. Again, it could be that it's interference with the potential to engage in activity that is actually the cause of the issue. There doesn't, again, as I just said, need to be an adverse action, and MSHA actually takes the position that they don't need to prove motive. So there are these two tests out there. The Franks and Hoy test suggests that if the action is reasonably viewed from the perspective of the protected class, so the minors, and under all the circumstances, as tending to interfere with the protected rights, and the person doesn't justify that action, the adverse action, with legitimate and substantial reason that outweighs the harm caused, that can be enough to demonstrate interference. So under that Frank's test, it does not require intent on the part of the operator. It's sort of the reasonable view of the person who's impacted, and that there's no, justification for the action that would outweigh the harm caused in sort of chilling the protected activity or interfering with the potential protected activity. And then Pepin is the other case that, again, has sort of the similar reasonable perception of the minor, the protected class. But those don't, that in that section, the second step, and under that test, the Pepin test, the second step says that the actions taken by the operator, the interference actions, were actually motivated by the exercise of protected rights. So that there was sort of I don't want to say ill intent, but there was intent and motive behind the activity that was taken, the interfering activity that was taken. And so MSHA obviously favors the Franks and Hoy test, where they don't need to prove motive. But it is sort of a question that's out there. A lot of the cases, or some of the cases, I should say, that we've taken a look at. Basically, you'll see here, like the Marshall County coal case here, they basically said, the DC Circuit said, this is clear under either test. And so we don't need to decide which is the appropriate test. So there is some sort of question out there as to whether, which one is the appropriate test and which courts might apply. This case involves some awareness meetings at mines at a mine. Oh, actually, multiple mines owned by Mr. Murray, and those awareness meetings, the courts determined that the tone of those meetings basically interfered with or chilled the exercise of protected rights or protected activity. And so, it wound up that they found interference there. Continental, this one doesn't actually address interference specifically, but it talks to intentionality. And so therefore we might think that that could favor Pepin here in the Eighth Circuit, in that, you're looking at the intent of the operator, intentionally treating someone worse because of a protected characteristic. Could think similarly, you would need some ill intent or motive in taking an adverse action based on protected activity. Again, not case specifically addressing the interference issue under 105C, but could speak to it, analogously. And then in the final case there, Wesley Mallory, there was a minor pled the case sufficiently to prove adverse action, because the interference there would dissuade that minor from engaging in protected activity. And as we said previously, that may constitute its own adverse action. So really the interference sort of serves as the adverse action itself, in the view of these, at least that was the FEMSHRIC there making that decision. So then addressing temporary reinstatement, and I know we are coming up on time, so I want to keep moving promptly here, but just to sort of, this is something that Nick will also speak to, but temporary reinstatement can either be actual, meaning you have to return the person to their job after they file a complaint, or economic, in that they will continue to receive their pay and benefits while the issue gets resolved. This moves really quickly, and the complainant needs to provide a reasonable cause. And so if the TR claim is not frivolously brought, you're going to wind up in a place where reinstatement happens. Either the actual, or I would say, anecdotally, I've seen certainly more the economic variety. Rather than restoring someone to actual employment, you wind up paying and providing their benefits while the system addresses their complaint. But again, as long as their claim is not frivolously brought, it's a very, very low standard, then they they will basically be granted temporary reinstatement. And I think ALJs are pretty, they accept this low bar, they employ this low bar, and it happens regularly where temporary reinstatement is granted. Again, a few cases. I don't want to belabor the points here, so I'll just run through them quickly. But here, the Sixth Circuit determined that temporary reinstatement doesn't need to continue after the secretary makes a determination that the complaint lacks merit. So initially, the secretary may find the claim was not frivolously brought, which puts you in the world of temporary reinstatement. But the secretary then continues to investigate, and at that point determines, okay, it wasn't frivolously brought, but we can't substantiate it. We don't think the claim has merit, and we're not going to bring the case on behalf of the minor, the merits proceeding. Here, the Sixth Circuit said when that happens, that means temporary reinstatement is over, and they dissolved the temporary reinstatement order. Similarly, and they found some ambiguity in the statute and the regulations, not as important. Similarly, in the Seventh Circuit, they actually didn't find ambiguity, but reached the same result. When the secretary finds no merit to the complaint, that order, the temporary reinstatement order, gets dissolved. In shoot, sorry, in Hargis, the ALJ, this is the commission making a decision, and there is a distinction here. And so this is why some of this is a little bit up in the air when it comes to the standards that get applied. But the ALJ erred in dissolving the temporary reinstatement order when dismissing a discrimination claim. The commission found that it should be 30 days after a commission decision, or if the commission declined review, then 40 days after the judge's decision. And that's based on requirements in the act. Um, this is also different because this is distinguishable. Here, it was the issue in the first two cases there, the minor was the one pursuing the cases. But in Hargis, it was actually the secretary continuing to pursue the minor's claim on behalf of the minor. And therefore, the commission distinguished it from the two cases and said, hey, these need to be immediately dissolved. So again, the standards, can shift. They can move a bit. You need to be kind of consult competent counsel if you wind up in this situation, not only because of these complicated legal issues, but also because, as we mentioned, you wind up in a very quick and active investigation and temporary reinstatement proceeding when this kind of claim comes forward. And with that, I think I'm kicking it back to Nick for the next section.
Yeah, thank you. And I think that it's important when we're talking about TR, and Scott ran through a very good review of that. I mean, we could do entire webinars just on temporary reinstatement and how that process works, but the judges can order physical reinstatement to the work site. The What we usually see when we're going through this process is that, you know, employers, you typically have a reason for why, especially in the instance of termination, someone was let go. There's a disagreement about why that was related to, alleged protected activity, but you can agree typically to do this economic reinstatement that Scott mentioned. And so it's important though to know the distinction that the parties can agree to this, and the judges will almost certainly approve it, but the judge cannot themselves order economic reinstatement, just physical reinstatement, which would mean the person has to go back to work at the same position, same duties, etc. That could be, if you have multiple operations, at another mine, but it has to be, somewhat agreed upon to an extent. There can't be any arguments that this is a less desirable location or it's further and harder to get to. So there's a lot that goes into the whole TR bit. But Scott's right. It's moving quickly, and that's one of the things that we want to touch on here is just the timelines. So these 105C cases, they kick off, and MSHA has 60 days to essentially complete their report, right? It's 45 days after the complaint is filed, then it's submitted to TCID. TCID has to do a review, then the solicitor's office will do it and file a complaint. That's kicked out about 90 days. But if we're talking about temporary reinstatement, the first initial investigation has to be completed within 15 days of the application for TR. So, Scott mentioned you do this temporary reinstatement investigation, and then MSHA continues to investigate the merits. It's almost two separate investigations, although there's a lot of similar facts in there. So responding quickly and appropriately and finding out as soon as possible whether or not MSHA is looking at temporary reinstatement is very important as you get into this. And a lot of times when, someone calls us and it says they have this letter about 105C, what is that? What do we do now? The first thing we'll do is get in contact with the investigator, get a bit more information on the scope, figure out if they're looking into temporary reinstatement in addition to the merits, and then our approach, we can move forward and strategize our approach with that information known. But otherwise, you are going to have a bit more of attenuated, if they're not looking at temporary reinstatement, right? But still, it's 45 days to do the investigation and for you to submit your position statement in order to have it on the record. And unlike 110 investigations that seem to languish and extend, time and time again, these move under these timelines. And MSHA does really stick to them, at least in the investigation part. Sometimes the review by TCID and the solicitor's office, those can get a bit attenuated, and they can languish a little bit there. But the SIs are going to do everything they can to get these done in 45 days. And if you're not being an active part of it and you're not giving information or providing that, they're just going to move forward with their investigation with the information they do have, which is likely coming from the complainant. So what do we do when we, have this complaint come in? First off, one, if we're getting MSHA complaints phoned in, we shouldn't care who's making them, right? And that's to protect ourselves against the potential for retaliation. If there is an MSHA complaint and then there's a 105, and then someone gets fired and there's a 105C complaint, you can guarantee the investigator is going to say, did you know who filed that? If so, how? Did you try and find out who did it? Were you asking questions? So, to the extent we can, ignorance is bliss in terms of just not looking into that. If we know who made it, which we often do in these circumstances, and the person's still employed, make sure there's no retaliation. Make sure you're not doing something like singling that person out for a talk or a question. If you feel like there is a need to address the workforce based off of with a complaint, you do it with everybody there. But you want to pretty quickly, in the sense that you get a 105C, you will know who the complainant is. You want to do your own investigation. You want to figure out, was it a timely complaint? You want to start looking at documents. You want to start interviewing people who might have knowledge. And you want to make record of your investigations and findings. And if you're working with counsel, if you're hiring, us to do this, this is what Scott and I are going to do with you, right? We're going to go through and try and figure out what are the merits of this complaint, what are the documents that, either prove it occurred or prove it didn't occur, and what do we do there in terms of preparing our response? Because a lot of this is going to come down to the information provided to MSHA. The big part of this is going to be interviews. We're going to put together our written position statement, and that is going to be a summary of all the information, but MSHA is going to focus on interviews. That is going to happen early and often, with both management and non-management employees. If management employees, if you have legal counsel, management employees, should be meeting with MSHA with the presence of your attorney there. But the, right to have a confidential interview with MSHA is the right of all minors, whether you're management or not. The investigator will request, and likely that first letter, the personal contact information for employees. We have to provide this to MSHA. If we have a mine with 700 people working at it and we think it's a smaller group, we can discuss it with MSHA about limiting it. But that has been litigated quite a few times about whether this information can be withheld, and generally we have to provide it. What you can do at this point, though, is you can notify your workforce that, one, there is this investigation, that you had to provide their personal contact information, and that MSHA will or may be contacting all of them. It's not uncommon for these special investigators to call people directly on their cell phones or reach out to them in person, even by going to their homes and just showing up unannounced. So, you can make the minors aware of their rights, the right to participate, the right to participate confidentially, or have anyone present when they're talking with MSHA. That is their right, and they control that interview process. But just be aware that they need to be aware that MSHA can show up unexpectedly and contact them at their own residence or otherwise. A lot of times when we're working with MSHA on this, we offer to coordinate and make people offer the employees, give us a list of who you want to talk to. We can try and make everyone available at work during working hours, and we can coordinate there. But still, you'd expect these special investigators to reach out directly to these employees. MSHA is likely going to request documents too in the form of employee files. That's not uncommon for us. Then all this information that we kind of gather, we're going to put together in our position statement. And this is going to be both factual and legal. It's going to provide the background and then the context for the basis of the charge. So what are people's job duties? What does that discipline program look like? What maybe past discipline or unsafe actions or whatever the relevant information there could be apply to this employee, and if their person was terminated, what is our justification for doing so? That all needs to be laid out in the position statement, and that's what we want it to contain, because our goal here is to give context, right? We are putting forth our argument. The complainant is talking with MSHA, they're talking with a special investigator, and they are giving them their point of view. And if we don't provide ours and provide it clearly, we're not asserting ourselves and not defending ourselves. So we want to tell a story. We want to be forthcoming with information. We want to make sure that MSHA knows we're taking it seriously. We are ultimately trying to get them to find that the complaint doesn't have merit by providing, facts and supporting documents that, support that facts and prove our point that maybe we followed our progressive discipline program. And this person is, claiming they made a safety complaint, but we have no record of it. But we also have, 4 documented cases of insubordination or tardiness or unsafe behaviors. And that aligns with our progressive discipline program. So these are the things that we want to lay out there in the position statement so it's quite clear. In terms of our, team, we want to make sure everyone's trained on this and familiar with it, right? These are the types of visits from MSHA that you have to be able to quickly distinguish are different than a normal inspection, right? And then even getting before that, we need to make sure that supervisors and managers are trained on what our expectations are for discipline, what our progressive discipline program might be, how do we document those events, how do we document coaching events or suspensions or whatever it might be, because if we are not treating everyone equally, it can be used against us in these investigations. So they should know how to respond to complaints, whether they're internal about unsafe actions or lack of training, or a complaint made to a regulator. If you're considering adverse actions, what is your process for coming to that conclusion? Do they have to run it by HR? Do they have to run it by a supervisor? Do you have multiple people in each meeting where discipline may be handed down? Those are all important things that you have to make sure your managers, your supervisors are aware of and trained on, and that you have that process in place, and that make sure that we're adhering to it, right? That is incredibly important, because that consistency is essential to your defense in the event that an investigator is on site. So you want to have that playbook for responding to complaints, whether they're about safety and health from your team or anything else, and that we follow up on those and we follow along quickly. We need to train our employees on how to, respond to a whistleblower complaint so that they don't immediately kind of jump off the rails when they hear that MSHA's got a complaint investigation going on. Make sure all miners know their rights. As I mentioned before, be able to differentiate why MSHA is there. This isn't a 2 and 4. This is not a regular inspector. These are their special investigators. They have additional training. They use different tactics for getting information. They're typically got much more pointed questions and approaches during interviews. So you need to be prepared for that. And always just remember, if you're talking with MSHA, expect that what you're discussing with them, whether it is a regular inspection or not, is going to be written down in the notes somewhere. But that is especially true in the course of an investigation. Just assume that any conversation that you're having with the investigator is going to be recorded in some fashion. I don't mean that means it's being recorded on a phone or a tape player, but it's going to be written down later. And then just, really, we think these are situations because of how quickly they move and the confusion on the case law and the ways that they can really escalate quickly with the financial penalties of, temporary reinstatement and the length that that could go during litigation if you don't defeat it in the merits investigation. It's important to contact legal counsel. Now, whether you got internal resources or you're contacting someone external, like us here at Con Marcel Carey, that's a corporate decision internally you guys got to make. But really, just don't. If you get a 105C, you can't sit on it. You got to move on that quickly and notify counsel and notify senior management as soon as possible so you can get those resources there. Um, and then Scott, I think you've got some best practices for us to close things out.
Yeah, and I'll try to go through these quickly because I mean we're over time and I know we've probably hit on a lot of these, but you want to make sure you have a clear and clearly communicated complaint policy that's written, that it's understandable to the folks that you're distributing it to. Make sure that you're ensuring there's no retaliation for engaging in protected activity, such as reporting hazards or participating in an MSHA investigation. Lay out how things should be reported, how complaints should be made, and what that's going to look like, what the investigation process of that complaint is going to look like, and be sure to actually do the investigation. Make sure that folks feel heard, and if there's a legit complaint about a potential hazard that you take a look into it, and also regularly evaluate the process to make sure it's working, to see whether it needs improvement. Should be kind of a living policy, that if there are ways to make it better, then look to implement those, and all of that sort of helps mitigate risk you have from potential 105C complaints. We talked about documentation. I won't hammer this home too much, but make sure you're documenting your activities when it comes to discipline. And if you're making decisions that could be viewed as adverse to the minor, not just discharge, but other sort of changes in responsibilities or roles, even changing shifts, things like that could potentially result in a complaint, if the minor sort of feels that it was adverse, and impacted their employment negatively. Document that includes documenting training on this policy and other policies and procedures. Again, we talked about on the last slide, making sure you actually do the investigation. Those should be documented too. If you take an interview, keep notes of that. Record why you did something. Why did you take that adverse action? And just make sure that that's all there. As Nick said, you're going to write a position statement, submit a position statement. It needs to be supported, and supporting documentation that is contemporaneous and shows why it was not the protected activity, but it was, for example, underperformance that resulted in the discharge. That all helps to address the 105C complaint. And then finally, treat folks consistently. If you have that consistent policy, you engage consistently in executing it, you conduct consistent investigations, all that goes a long way to showing that you're not making arbitrary decisions, or worse, you're not making decisions motivated by that protected activity. You want it to be non-retaliatory. You want to follow the guardrails, and you should be able to show that another employee who made a similar complaint, similarly situated employer made a complaint, employee, excuse me, made a complaint. They're treated in the same fashion as the person who complained, submitted a 105C. And that shows that you're being consistent. You're not targeting any one individual for their protected activity. You're treating these seriously, consistently, and you're making sure to document your decision making, and you're making decisions based on legitimate reasons, not based on ill motive, ill intent, because the minors rep or applicant engaged in protected activity. And I think that's the last substantive slide, Nick. I'm going to turn it to you to speak about our webinar series.
Yeah, thank you very much, and thanks all for sticking with us here a couple minutes over today. Been a great discussion. I think there's a lot of great information here. Hopefully, you guys have found it helpful. If you have questions specific to any, whistleblower claims that have come out, whether it's under the Mine Act or if you have operations that are under OSHA on the OSHA side, or just any other kind of general labor, employment, or whistleblower questions outside of the safety context, let us know. I obviously focus my attention on the MSHA world, but Scott has a lot of great experience on the labor employment side too, and he can definitely be a resource for you outside of the Mine Act statute on whistleblower protections. But looking forward on our webinar series for the rest of the year. So we've making our way through it. Our next one is going to be looking at compliance. Where compliance might converge between OSHA and MSHA and kind of co-regulated facilities or operations. We'll talk about that here later in about a month from now. And then we'll getting down to the last half of this year's webinar. So if you've been with us for the one so far, thank you very much. And we hope you'll continue to join us for the rest of the year. If you are out in California or in the Midwest, we have a couple in-person summits coming up this year. The first one, or the sooner one, is going to be in Detroit in June. If you're interested in heading over to that, feel free to reach out to either one of us directly or to our general info box, and we can get you some additional information on that. And then also in Northern and Southern California in October. And lastly, as always, we welcome you to follow the blogs, whether it's the MSHA Defense Report, the OSHA, the Employer, or the Cal OSHA. If you're specific out there operating, we always keep those updated with information and deep dives into specific topics that might be of interest to y'all. As we mentioned before, happy to take any questions. I don't see any in the chat right now. So we'll leave that chat open here for another couple minutes. If you guys want to log some questions, we'll get back to you. If not, feel free to contact myself or Scott at any time, and we'd love to talk with you and be of support. So thank you all very much. Like I said, we'll keep this open here for another minute or two if there's any questions, but otherwise, we'll let you get back to your day. Thanks.
Appreciate it.